Serena Fulton, the mother of Trayvon Martin, went to Capitol Hill to testify about stand your ground laws. 30 states, including Florida, have some form of stand your ground law, declaring that an individual has no obligation to retreat when attacked. This hearing of the Senate Judiciary Subcommittee on the Constitution, Civil Rights, and Human Rights is an hour and a half.
I'm sorry, if I can ask you all to please stand. It's customary to administer the oath before this committee. If you would please raise your right hand. Do you affirm the testimony you're about to give before the committee will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Let the record reflect that all witnesses on the second panel answered in the affirmative. Each witness will be given 5 minutes for an opening statement. Of course, any written statement they'd like to submit for the record will be admitted without objection. Our first witness is Sybrina Fulton. Ms. Fulton is the mother of Trayvon Martin. Her son was shot and killed at the age of 17 on the night of February 26, 2012 in Sanford, Florida. Sybrina and Trayvon's father, Tracy, have co-founded the Trayvon Martin Foundation to create awareness of how violent crime impacts the families of victims and to provide support and advocacy for those victims. Ms. Fulton is a graduate of Florida Memorial University. Thank you so much for coming here today, Ms. Fulton, and please proceed with your testimony.
Thank you so much for just taking the time to listen to what not only I have to say, but the rest of the people that's testifying as well. By nature, I'm a mother of 2 boys, and I still support both my sons. Although Trayvon is not with us, it's very important that I try to make a change for not only my oldest son, Javaris, which is still here on earth, but also Trayvon. It's unfortunate what has happened with Trayvon, and that's why I feel like it's so important for me to be here so that you all can at least put a face with what has happened with this tragedy. Trayvon had recently turned 17 years old. He had only been 17 for 3 weeks. We celebrated his 17th birthday on February 5th, and he was murdered on February 26th. So he had only been 17 for 3 weeks. It's very hurtful to know that Trayvon was only simply going to the store to get snacks. Nothing more, nothing less. It's important to keep that in mind because teenagers like to be independent at times. And he was simply going to get a drink and some candy. That tells me right there his mentality. That tells me that he was not going to get cigarettes or bullets or condoms or other items of that nature. He was going to get a drink and candy. Trayvon was minding his own business. He was not looking for any type of trouble. He was not committing any crime. And that's important to remember, that the things that surround the tragedy that happened are most important. At the time that this happened to him, he was on a telephone call with a young lady from Miami. That shows his mentality. That shows that he was not looking for trouble. He was not the criminal that some people have tried to make him out to be. He was not the criminal that the person who shot and killed him thought that he was. He was simply on the cell phone talking to a young lady in Miami with candy and a drink. As I think about this as a mother, and I think about how many kids walk to the store and how many kids now feel that they cannot be safe in their own community, I think about what kind of message we are sending as parents, as lawmakers, as elected officials, even as grandparents and aunts and uncles. What kind of message are we sending if our kids, because remember, these are our kids in our communities, don't feel safe? Don't feel safe simply walking to the store to get candy and a drink. So I just wanted to come here to talk to you for a moment to let you know how important it is that we amend this Stand Your Ground, because it certainly did not work in my case. The person that shot and killed my son is walking the streets today, and this law does not work. We need to seriously take a look at this law. We need to seriously speak with the state attorney's office, the police departments, more attorneys. We need to do something about this law when our kids cannot feel safe in their own community. Thank you.
Ms. Fulton, we're sorry for your loss, and thank you for your courage in coming today, as well as to Trayvon's father. Thank you very much for being here. Our next witness is Professor Ronald Sullivan. He's a clinical professor of law at Harvard Law School, where he serves as faculty director of the Harvard Criminal Justice Institute and the Harvard Trial Advocacy Workshop. He previously taught at Yale Law School and served as director of the Public Defender Services in the District of Columbia. He received his BA from Morehouse College and his law degree from Harvard. Professor Sullivan, thanks for being here, and please proceed.
Thank you very much. Good morning, Chairman Durbin and Ranking Member Cruz and members of the committee. Let me also join the chair and others in sharing and offering my condolences for your loss, Ms. Fulton. In order to properly understand Stand Your Ground laws, we must first appreciate the broader context in which they exist. First and most important, it's axiomatic that sanctity of human life is a central and animating value in our legal system. This, I trust, is not a particularly controversial claim. Dating back to our law's Judeo-Christian origins, interpreters and courts alike have recognized that human life is sacred, and those who would extinguish human life carry a heavy burden in order to justify such an act. Stand Your Ground laws, like all self-defense laws, require this heightened showing of necessity. The particular version of Stand Your Ground laws, which began with Florida's 2005 laws, differs drastically from other Stand Your Ground laws and from the common law of self-defense in three important respects. First, these laws remove the common law duty to retreat. This has the result of emboldening individuals to escalate confrontation as opposed to an alternative rule which would de-escalate confrontation. And the duty to retreat implies a duty to safely retreat. Second, these laws shift the legal presumptions regarding reasonableness of one's fear. Under a Florida-type law, the actor is presumed to be reasonably in fear of imminent death if he's in his home or automobile, and this presumption abrogates the need for someone who is responsible for a homicide to affirmatively demonstrate the necessity of taking another human life. Third, these laws provide immunity from criminal arrest and civil liability. This has the unintended effect of encouraging the very sort of vigilantism that normal and ordinary law prevents. In my written testimony, I discuss all of these issues at length. I also analyze at length the extant empirical evidence, and I conclude that the data is not sufficiently robust to make a causal claim in either direction. So to say that Stand Your Ground laws increases or decreases the incidence of crime, I think there are correlations there. I haven't found strong causal evidence, but the weight of the evidence strongly points to the conclusion that Stand Your Grounds has little, if any, impact on homicide reduction, and the promulgation of these laws appears to correlate with an increase in certain types of violent crimes. Now, time does not permit me here to go into more detail, but I'll make some observations about the Trayvon Martin case. Mr. Zimmerman's acquittal was made possible because Florida's Stand Your Ground laws and its concealed weapons laws conspired to create the perfect background conditions for his exoneration. These laws permitted Mr. Zimmerman to carry a loaded firearm, to disregard the clear directive of a 911 dispatcher, to follow and pursue Trayvon, and then stand his ground when young Trayvon reasonably sought to defend himself. And all because I strongly suspect that Mr. Zimmerman could not apprehend any lawful reason for a young black male to be walking through his middle-class neighborhood. To Mr. Zimmerman, Martin's blackness likely served as a crude proxy for criminality. Now, this unfortunate outcome sends a twofold message. First, it tells Floridians that they can incorrectly profile young black children, kill them, and be protected by Stand Your Ground laws. But second, this decision sends an even more ominous message to young black children. So I consider myself fortunate to live in a jurisdiction that does not have Stand Your Ground laws. But what if it did? I have an African-American son who's just shy of his 13th birthday, whose name, ironically, is Trey. What advice would I give him? I regret the only responsible advice, if I lived in a Stand Your Ground jurisdiction, would be that if he ever felt seriously threatened by a stranger, then he would have to use all reasonable force, up to and including lethal force, in order to protect himself. Because I'd rather my Trey be alive and able to argue that he stood his ground than dead and portrayed by lawyers, the media, and present company excluded politicians as some stereotypical black male criminal. This is not a desirable America for anyone, and I don't want my son growing up in such an America. I respectfully suggest that states pass laws that permit police to police and citizens to go about the business of building communities. Thank you.
Thank you, Professor Sullivan.